Furman versus Georgia, the right to impartial sentencing.
August 11th, 1967. A man by the name of William Joseph Mickey and his family were asleep in their Savannah, Georgia home. Mickey woke during the night to the sound of an intruder and went to investigate the disturbance. He discovered an African-American man named William Henry Furman attempting to flee. A shot was fired and Mickey died.
At trial, in an unsworn statement allowed under Georgia criminal procedure, Furman said that while trying to escape, he tripped and the weapon he was carrying fired accidentally, killing the victim. This contradicted his prior statement to the police that he had turned and blindly fired a shot while fleeing. In either event, because the shooting occurred during the commission of a felony, Furman would have been guilty of murder and eligible for the death penalty under then extant state law. On September 20th, 1968, he was sentenced to death.
At the time of Furman's conviction and sentencing, the number of people executed was declining after the peak year, 1935, when almost 200 convicted felons were executed. Racial bias has always been a significant issue in death penalty debates. There have been many careful statistical studies indicating that race plays a significant role in determining who lives and who dies.
Many reformers felt that the death penalty was in and of itself unconstitutional and violated the Eighth Amendment's prohibition of cruel and unusual punishment. But they challenged the racial bias of the penalty and wanted to point out the discrepancies and capricious nature of capital punishment. In 1972, the case was finally heard by the Supreme Court.
Furman's case was argued by Anthony Amsterdam, and the state of Georgia was represented in oral arguments by Dorothy Beasley. The Supreme Court ruled in favor of Furman with a 5-4 majority, and required for a degree of consistency in the application of the death penalty. The case led to a de facto moratorium on capital punishment throughout the United States. Justices Brennan, Douglas, Stewart, White, and Marshall all concurred in the case.
The Supreme Court declared the death penalty unconstitutional today and spared the lives of 600 men in death row cells across the country. But the divergent opinions offered by the justices leave some questions about capital punishment still unanswered. For a report on the decision and some of the questions, here's ABC's Herbert Kaplow at the Supreme Court.
The vote was 5-4 against the death penalty. Justices Brennan and Marshall said it is cruel and unusual punishment and therefore unconstitutional. They would prohibit it entirely. Douglas wouldn't go quite as far. He said the death penalty has been imposed disproportionately on minority groups. More than half of the 600 people now under death sentence are black. Douglas left unanswered whether the death penalty administered equally might be legal for certain cases. Stewart voted against the death penalty because it's been applied in what he called a wanton and freakish manner. In other words, in not any consistent or uniform pattern. He pointed out that in the 3 test cases ruled on today, 2 of the defendants were convicted of rape and their victims were not killed. White voted against the death penalty because he said it's very doubtful it meets what White called any existing general need for retribution. So the 5-member majority went a long way, but not quite all the way, toward total abolition. The court seemed to say that if state legislatures established better standards for the death penalty, it might be proper for certain crimes. But as it stands now, the death penalty is illegal in the United States. The 4 judges who voted today to uphold capital punishment are the Nixon appointees, Berger, Blackmun, Rehnquist, and Powell. Herbert Kaplow, ABC News at the Supreme Court.
Potter Stewart wrote for the majority. These death sentences are cruel and unusual in the same way that being struck by lightning is cruel and unusual. For of all the people convicted of rapes and murders in 1967 and 1968, many just as reprehensible as these, the petitioners are among a capriciously selected, random handful upon whom the sentence of death has in fact been imposed. My concurring brothers have demonstrated that, if any basis can be discerned for the selection of these few to be sentenced to death, it is the constitutionally impermissible basis of race. See McLaughlin v. Florida, 1964.
But racial discrimination has not been proved, and I put it to one side. I simply conclude that the 8th and 14th Amendments cannot tolerate the infliction of a sentence of death under legal systems that permit this unique penalty to be so wantonly and so freakishly imposed.
Chief Justice Burger and Justices Powell, Blackmun, and Rehnquist dissented on the grounds that capital punishment had always been regarded as appropriate under legal tradition for serious crimes, and that the text of the Constitution implicitly authorized United States death penalty laws because of the reference in the 14th Amendment to the taking of life.
Justices Brennan and Marshall felt that with this landmark decision, the United States would follow the lead of other democratic nations and abolish capital punishment. That was not to be. In the 4 years after Furman, 35 states wrote new laws regarding the death penalty. New guidelines and sentencing techniques were created. The death penalty was now to be applied only to first-degree murder accompanied by aggravating or mitigating circumstances.
I think unconsciously they must be thinking or coming to a conclusion that this person really doesn't have anything worth saving, or this person is going to be a threat if he continues to live. So I think the most compelling evidence, the most persuasive evidence, is probably the fact that the person has committed other murders, had a significant criminal history of violent crimes against people, rapes, robberies, aggravated assaults, that might be very persuasive. I think torture is the third thing, because it just shows a lack of humanity in the person who's being tried, that he doesn't care for another human being and simply wants to inflict pain for the sake of inflicting pain. And I think that tells a lot about the person to the jury.
Mandatory sentencing and capital punishment for rape were declared unconstitutional.
The attempt to remove racial bias in capital cases has not been totally successful.
Is your current view on the death penalty the same as it was back when you argued the case?
No, I think in many things in life, our ideas about things change. Some things never change, but many things in our society change. Things happen, we get older, we get more experience, but the outside world, many things change in that. And we've had now many years of trying to use the death penalty in a constitutional manner. Haven't fully succeeded yet.
A report sponsored by the American Bar Association in 2007 concluded that 1/3 of African American death row inmates in Philadelphia would have received sentences of life imprisonment if they had not been African American.
A January 2003 study released by the University of Maryland concluded that race is a major factor in death penalty decisions. Specifically, prosecutors are more likely to seek a death sentence when the race of the victim is Caucasian, and are less likely to seek a death sentence when the victim is African American.
A 2007 study of death sentences in Connecticut conducted by Yale University School of Law revealed that African American defendants received the death penalty at 3 times the rate of white defendants in cases where the victims are white. In addition, killers of white victims are treated more severely than people who kill minorities when it comes to deciding what charges to bring.
In Furman, the Supreme Court basically said, well, the death penalty is too arbitrary and capricious.
Furman v. Georgia was a landmark case that attempted to eliminate racial bias in the application of capital punishment. Although we have taken great strides in the right direction, it is our responsibility as Americans to keep improving the sentencing process in our judicial system today.
Furman versus Georgia, the right to impartial sentencing.